PIC in relation to this.
Who signed the separation agreement on behalf of the PIC?
So I was the employer representative, so I did sign on that behalf. So I was delegated at the time by the CEO to the affairs of representing the PIC, so I signed it.
Now, can I ask you, Mr. Pulwani, since date of signature of this separation agreement till last night, did anybody at the PIC ask you about your views on the merits of this agreement?
Not that I can think of. What you may find is just comments out, but not any formal view around what I thought about other than last night or early this morning. I think early this morning.
Thank you. Can you then deal with the disciplinary of the executive head?
Sorry, can I just
question?
ask?
Yeah.
Well, this is something that seems to permeate a lot of the discussion, this dissatisfaction about this particular mutual separation agreement. Were there other separation agreements that had been signed before? And what is the issue in this one that has caused such repercussions with board and shareholder? And what does it mean in terms of your 5132C? Some of the facts that subsequently came out post the mutual settlement agreement indicated behavior that is incongruent to PIC values and code of conduct. Does that mean that if things came out post a settlement agreement that were not disclosed or were not aware, that it could nullify the agreement or should nullify the agreement? And were the terms of settlement so different that it's had this repercussion? I mean, I don't understand why one item, unless there's something very distinct about it. So what is distinct about it? And when you said you've informed the board, but the board wasn't aware of the terms, surely the most important question is the terms. Yeah. Because you set precedent with terms.
So, Chair, if I may respond, so definitely it was a precedent-setting settlement which dealt with the value of 29 months of the guaranteed pay of the affected individual, 29 months of the value of that guaranteed pay of the individual. In other words,
so they were paid for more than 2 years, 2.5 years.
That is correct. Yes. So I would imagine from a precedent point of view, so that was would be the issue, I would imagine. The settlement on its own, it's an outcome of a negotiation between the two parties, where there will be a position expressed, and in this respect, there was issues that were tabulated to the employer. Amongst them was the potential loss of incentives, both short-term and long-term, if the employee was to, exit the organization. And then they would also look at the potential to be able to be employed within a specific period of time, as we all have an appreciation of the unemployment rate in South Africa and opportunities in respect of certain skills. So those will be some of the factors that would influence the discussions in and around the separation. But equally, and I need to state this, both parties were represented by legal counsel. The separation was entered, the agreement was entered to voluntarily and was made in good faith. And I think that's very important to grasp. If there's anything untoward, and the Commissioner had referred to the facts as established on page 15 on number C, those facts came out of a disciplinary hearing, which had we had those opportunity, and I agree, the settlement, or if required, the disciplinary process would have continued had we known those at that time. Yeah. So the other part that you dealt with, Commissioner, was whether this should be set aside or nullified. I think it would be important for the Commission to also assess this component as it remains an issue of consternation, to educate for itself if this needs to be set aside. But I would also indicate and advise the Commission that all facts and all parties need to put their point across in terms of what really occurred in this instance, from the onset up to the conclusion thereof.
Just to be clear, so according to you, I mean, including all the calculations you mentioned, was this done within the PIC policies?
Yeah, within the policies, as I referred to, you know, from a policy point of view, it's an outcome of a disciplinary hearing, and then you may want to settle. You don't police or have something that says you will have mutual settlement, you know, as a form of a policy. So there's a decision and a sanction, or you arrive at a certain decision in disciplinary hearings, and then you'll deal with that. What probably the Commissioner may want to direct the question is to, was this prudent? And I think that was attended to. Was it made in good faith? In the fair, so it is precedent setting.
Mr. Commissioner, if I can assist at this stage, just to place on record that we have already consulted with the former head of IT, and she has indicated that she is keen to come to the Commission to tell her side of the story. So she will be called as a witness.
I think that would be very helpful, because the other 2 points that you make in the outcome of the disciplinary are very concerning, and you qualify it by saying it appears that. But it appears that first, from your wording here, is that this was an investigation by the police, and that during that investigation she was conveniently out for lunch, and therefore was not part of that and was absent during that. And secondly, that the allegations, if correct, are extremely serious to come to any settlement that gave administration rights to senior managers in IT to access PIC systems, to monitor senior management emails and other confidential information outside the scope of work. Now that is a very serious allegation in my view, if you're looking at confidential information that is, you know, that people can make a lot of money out of. So I think if those were the allegations, then a settlement of that nature does get called into question. So I think that if she is coming to appear before the Commission, that would be helpful to answer the allegations, because clearly those allegations have not been settled.
Absolutely. So Commissioner, and that's the point around pointing that out. In a case that this was to be questioned, you say these are areas, these are allegations that still need to be tested, because as it occurs, they came to light, you know, at the duration of another disciplinary hearing, and we came about that. There were some elements in the forensic report, but you could not conclude, convincingly that this was indeed the case until such time that that information was volunteered into that disciplinary hearing. And there's a record to that effect, which I think needs to be tested, as it were. I must also indicate that I think late last year, around December, we had received a letter as PIC from the affected employee that they wish to tender their submission to the Commission, and in some instances deal with this issue or any other matter that they would deal so. So I understand that that is the case.
I just want to check something. These terminations of employees, are this part of the whistleblowing issues? Are these people who were sort of fingered in the SNG report? Or this could be separate things?
Commissioner, I think, you see, when one says whistleblowing, I'm unfortunately going to have to take you through a process of whistleblowing. Mm-hmm. PIC has got, and I hope that the head of internal audit will also deal with that extensively. Mm-hmm. PIC has got a whistleblowing process and a policy. We call it fraud prevention. and which I think the head of risk normally would deal with that policy. By and large, there's a process in which any whistleblowing by an employee, they are encouraged. And I would add, we have received a few of them, and in some instances, those have been investigated, but that's not within my ambit. That's within the ambit of internal audit. It is only until I get a report that will require HR to intervene, then that I would intervene. But the whistleblowing policy and process is there and is available. Nothing at this stage, in terms of the disciplinary hearings that we've conducted, has pointed out, nor anyone throughout this process has indicated that they are in actual fact are whistleblowers or were whistleblowing. There is an reference, but there's nothing specific that says, in actual fact, my actions was that of a whistleblower, and therefore they will fall within the necessary protection that is afforded to whistleblowers. Up to this stage, there are just vehemence towards that, but nothing concrete.
So basically, we're saying it's really part of the leaking of the some information then.
Well, I'm not saying it's part of, I'm indicating that I don't have anything at this stage. That is in my evidence that suggests that this was a whistleblowing activity. From a leaking of information, those are areas that we dealt with in a disciplinary action, where a report pointed out that an individual accessed certain information, and that information was distributed to other forums. That part I'm aware of, and it's on record in terms of the disciplinary hearings.
Then we can conclude with the disciplinary of the Risk and Legal Council, Governance and Compliance. As I understand the situation, Mr. Pulwane, is that both of them served on the board of the VBS Bank.
That is correct. They were nominee directors of the PIC to an investee company.
Yes, and the action taken against them is directly connected with their failure to act in the best interest of the PIC while serving on this board. Can you just
perhaps I can
explain?
elaborate and maybe just deal with each occurrence. So the executive head of risk specifically, the disciplinary process particularly focused initially on performance management and leading and managing the risk function. So those were areas that were proffered from a charge's point of view to the employee. What came to surface was and we couldn't prove this at the point and at the time of the disciplinary hearing, is the fact that there was some, if you like, overlooking of fiduciary duties or fulfilling of the fiduciary duties that they would have been entrusted as directors in the nominee, as nominees in the investee companies. What this would mean, and I don't want to probably deal with governance and issues whether you have a duty to inform or not, but what this would mean is that if there's any information, and this was tested in the disciplinary hearing, particularly with the head of risk, that it is impossible not to be aware of the goings and the operations of an entity, especially in matters dealing with litigation. And let me maybe explain more what I mean by this. There was information that came to light that...
Sorry, can you talk closer to the mic?
There was information that came to light that during the disciplinary hearing that there was a litigation against this investee company that was in dispute with National Treasury if whether they will be recipients or take deposits from municipalities, as it were. And it would be odd for a director not to be aware of this litigation against an institution that they have oversight on. And this was tested. And I think that's where the areas of suspicion around their role in this regard. What then emerged subsequently with I think the investigation conducted by the Reserve Bank was that these nominee directors were fingered to have been participants, at least in the maladministration and overlooking what actually occurred in that institution. So when this was brought to our attention and with the head of risk, we dealt with performance management issues and that duty of good faith not being exercised, as well as the fiduciary duties exercised, and the employee was dismissed. And the matter currently is still sitting with the CCMA and has been referred there. With the head of legal, when that information came to fore, we were advised by a letter, I think, from the Reserve Bank that PIC needs to take corrective action, as they became aware that our nominee director was also involved in this maladministration. Immediately when this came to our attention, I'd engaged the CEO, who then informed me that this was the information that he had received, and advised him that a suspension needs to be issued, and I set up an appointment with the affected employee for the following day, because I had learned about this later in the afternoon. And in the morning of the intended meeting, a resignation letter was submitted to PIC, and that's how the employee had left the PIC.
I think when we're looking at some of these things, it would be useful perhaps just to dateline some of them. It's sometimes a bit difficult to know, given the period just when this occurred. But that's one type of action against this. These are two very senior people. Your head of risk, a very critical element in the PIC, and your head of legal, on whose advice I'm assuming the PIC depends a great deal. Has the PIC taken steps to look into everything over a period going backwards or forwards, but certainly backwards, where risk and legal have advised and made recommendations, and to see whether there were other instances by these people of either disinformation, misinformation, manipulation, or something that was improper? Because I would be very surprised if there's only one instance. How would there only be one instance if people do this in relation to, and perhaps you want to name the entity, because, I mean, people know what the entity is, but it would be useful to say, if you've done this in relation to this entity, knowing these are your responsibilities internally in the organization, have you looked at whether, in fact, this is a red flag for other advice, deals, information, assessments? Because why would it be one deal only?
So, Commissioner, what I'm aware of at this stage is that and I stand under correction, the internal audit team had been informed, and there is an investigation currently underway to look at the particular individuals and if there's any more. I don't have the details of that investigation, but I'm aware that there is an activity that is underway with regards to that. Whether it's only this specific entity, and you said naming it was VBS. So if there's anything other than that, I suppose that is something that would also be looked at. But I'm not aware of the total scope of that investigation. What I can also confirm from an activity point of view that has also occurred, and I think this information was communicated, I think in a parliamentary committee, I'm not sure when, that the PIC will be looking at either pursuing criminal charges, if that's the route that will follow, to ensure that this is addressed. We have also made submission, or are in the process of making submission, to deal with their status as board members. I think there's a process underway in terms of that. What I can confidently confirm is that we had debarred them in terms of the FACA, so the Financial Services Yeah. Financial services, yeah. So we've done specific action to prevent the two individuals from providing financial advisory or even to deal with it going forward.
Notified the Financial Service Conduct Authority?
Yes, we had done that, yes.
My last question, in terms of the proclamation, in terms of reference, do you have any personal knowledge of any impropriety regarding investment decisions by this PIC that was reported in the media in 2017-18 contravening any legislation, PIC policy, or contractual obligations?
So, Chair, the only information currently to my disposal is that which I've dealt with right now of impropriety which came about as a result of the investigation by SAB. I do not have, prima facie evidence in terms of any other employee, not unless, it has been brought to my attention and I didn't pay attention to that. That would be odd, but nothing so far that came to my attention other than these two aspects that were related to the VPS saga.
Do you have any personal knowledge whether a director or employee of the PIC used his or her position or privileges or confidential information for any personal gain or to improperly benefit another person?
So what I'm aware of particularly is in relation to the two reports that were conducted and which were subject of disciplinary hearings. One, it's a matter that's under consideration in terms of the disciplinary hearing as we have, which is the SNG report, which provides indication that some information that employees may have come about could have been used for other means other than what is intended to. But that is still a matter that is subject to adjudication. The other one was confirmed in a disciplinary hearing where that information was obtained and used, and as we currently have the state status quo, and this is in respect of the senior manager in IT, security risk, and governance. The other information that I potentially could be aware of, and maybe Commissioner Lidija, you referred to whistleblowing. There was a whistleblowing incident reported sometime last year, I can't remember the specific time, which the internal audit investigated, which the public protector also investigated, and it was in relation to either on alteration or manipulation of remuneration and incentives. What I'm aware of, there was an employee within my department who made an affidavit, and I hope that that person will present themselves in this, who may have had access to privileged information, and I would venture to say that used it to either his benefit or benefit of others.
Thank you. For the record, Mr. Commissioner and members, employees and former employees have approached us with information. We're in the process of consultation and drafting of statements, and depending on what they come up with and if they present their cases before the Commission, Mr. Pulwani must just be warned that he may have to come back to the Commission to answer to those allegations that may or may not be brought before the Commission.
In fact, Advocate Libber, the three of us discussed that and sort of realized that what we should have done with regard to all the witnesses, to inform them that they might be called back to come and give further evidence, should it be necessary.
Yeah, I can give you the assurance that I have done so, although it's not on record, but I've informed them that this is the first stage of the investigation and the Commission work to set the framework of the work, but they will most definitely be asked to come back to answer to specific allegations.
Give us a number again. I didn't hear the number. The employees who have come forward? The number.
At the moment, it's about...
Oh, there was no number. You didn't say number.
I didn't say.
All right.
Mr. Commissioner, if there's no more questions, this is the work for the day. We are ready to start tomorrow morning again at 10. And according to the schedule, we plan to I think, adjourn at 11:30. We have the person who will testify tomorrow is the internal auditor. And according to our estimates, he will finish his evidence in an hour and a half.
Thank you. So for now, Mr. Polwane can be excused for now.
Thank you.
Yes, all right. And we can then adjourn until tomorrow morning. Right, the sitting will adjourn until tomorrow morning at 10. Thank you.
You're doing a hell of a job.